I respectfully disagree with the prior rulings of the court, believing that the court has to either make a finding of proof evident or presumption grade, or not find proof evident presumption grade, in order to detain Mr. Sanchez Hernandez without the benefit of bond. That burden, the state, my understanding is that the state would have to move to foreclose and present something before the court. Right now, what is before the court is a probable cause affidavit solely for the purpose of establishing probable cause and not proof evident presumption grade.
All right. Public Defender's Office has consistently made the opposite argument. Why?
Judge, for the record, I am here before the court on Jose Sanchez Hernandez. What the court is asking me now to do is go back to prior arguments. If there's a specific case or a specific argument that may have been made in the past, I could maybe address them. If I could get a transcripts of those arguments, I could address those particular arguments. I'm just specifically making these arguments as to the case before the court right now.
Do you want me to then have the Public Defender's Office pull every punishable by life transcripture from the last 3 months, and then you can come back in and explain to me why you've made the exact opposite legal argument?
Judge,
Because I'm
is the court ordering the Public Defender's Office to order transcripts on every punishable by life offense in the past? Is this an order of the court?
I'm asking you, Mr. Afsal. The Public Defender's Office has made inconsistent legal arguments. It leads me to believe that the Public Defender's Office doesn't know the law. And it's a little bit concerning to this court, I have to be honest with you. And so I'm trying to understand. We're playing around here with words and we're playing games, and I don't really appreciate it.
I'm not playing with games, Judge. What I'm doing is making a specific legal argument on this particular case. Now, if the Public Defender's Office,
We have some colleagues of yours from the Public Defender's Office. They're welcome to come on up here and explain to me a little about the game playing that's going on.
Sure.
Sure.
Don Canarachi, Assistant Public Defender. Here's my understanding.
I got to have you near a microphone.
Oh,
I don't think you, ma'am. What? Does she need to translate this?
Yeah.
Okay.
Don Canarachi, Assistant Public Defender. And my understanding, Judge, is that the court believes that we are making inconsistent arguments regarding whether this court should set a bond at first appearance for those charged with a capital offense or a first-degree felony punishable by life. Am I correct in that?
No. Let me correct you.
Okay.
For the last several months, the Public Defender's Office has argued that this court may not find proof evident presumption grade at a first appearance hearing. Then the Public Defender's Office has asked me not to find proof evident presumption grade at the first appearance hearing, but to leave it to the division judge. Today, the Public Defender's Office is asking me to find proof evident presumption grade. This leads me to believe that the Public Defender's Office does not know the law, does not understand the law, and are making inconsistent arguments. I'd like to know why.
Okay, and that's why I'm here to explain. And you may or may not be aware of this, but back in January of 2016, the Chief Judge issued an administrative order. Are you aware of that?
I'm aware.
And
I'm
in
aware
that,
that it was altered. Go on.
right, okay. Order says that you will only determine probable cause. Then Ms. Diane Cudahy wrote the letter to Chief Judge Weinstein suggesting
I'm aware of all
that.
this.
And then the new administrative order in January.
I'm aware.
So now we're back. And my argument is that the law is that before this court can hold someone no bond, it is the state's burden to either, number one, file a motion for pretrial detention, which I don't believe is happening in these cases, or number two, present sufficient evidence, and under State v. Arthur, as the court is well aware, that evidence means proof greater than beyond a reasonable doubt.
Okay, but I'm going to stop you right there.
Okay.
I need you to answer my question.
I will.
Now.
Oh, well, what's the question?
The question is, why has the Public Defender's Office been making inconsistent arguments for the last 3 months.
I don't know what the arguments that were made, Judge, but
right,
I'm
then
telling
I'm
you
gonna-
today what the argument
Okay,
is.
then I'm going to have you pull the transcripts on every punishable by life offense for the last 2 months. You're going to come in here and you're going to explain to me the inconsistencies.
Okay, but may I make the record today
Go ahead.
that whatever arguments were made before, the law is that this court cannot hold someone no bond unless the state proves proof evident presumption great. That is the Constitution. That is the law, and I do have a case if the court is interested in seeing a case that explains, and in fact, it was a case from the second DCA where this exact issue came up at magistrate, where the magistrate judge was not making the findings, and the second DCA said, in fact, before someone can be held
Then
without
answer
bond.
my question as to why the Public Defender's Office has been arguing consistently that this court does not have the jurisdiction to make a finding of proof evident presumption great at a first appearance hearing, and today you come in here and tell me the exact opposite.
I'm telling you what the
Explain
law
that
is.
to me.
I'm
Judge,
ju- I-
if I can just assist, the argument was being made pursuant to the administrative order, which was subsequently just recently issued.
What did the
on
administrative
January-
order say?
We have it right here, Judge.
Which one,
Administrative
sir?
order said that no Arthur hearings are to be held at first appearance.
Exactly.
The old
That is
administrative order.
not the argument that the Public Defender's Office has made. The argument is that this court does not have the jurisdiction to make a finding of proof evident presumption great. Explain to me why.
Judge, I can't explain to you why. I
And
don't know
pull
what
the
the-
transcripts. We will reset this case for tomorrow.
if-
Judge, I'm making the legal argument now that the Constitution
Set this
requires.
case for tomorrow. You will explain to me why the Public Defender's Office has made that argument. Wrongly, apparently.
Maybe it may be wrong. I mean, attorneys do make improper arguments, Judge.
Consistently, again and again and again on each case.
Yes, Judge, and one more
Maybe
time.
Ms.
What I'm
Gerald can
advising the
explain
court
that.
was that pursuant to, it was our understanding pursuant to the administrative order that came down back in January of 2016, that this court was not to hear arguments on first PBLs, Arthur hearings.
Correct.
Those were the arguments we made, was that this court could not make that determination here. Okay. Have I answered your question thus far?
No.
Okay, so I'm not sure which part of your question I'm not answering.
The
change came in argument.
The administrative order said no Arthur hearings at first appearance.
Right.
Not that this court did not have jurisdiction to make a finding of proof evident presumption great. Those are two different things.
Well, notwithstanding what those arguments were, Judge, the public defender
No,
stands.
no. The arguments are the crux of what we're.
That it's just maybe a mincing words.
We are not no.
If I can
Wait a
finish,
minute. We're
if I
not.
can finish my thought,
We're
Judge.
not mincing words.
I
No.
understand that.
We're gonna drill down to what the issue is
And
here.
I'm trying to do that.
I'm trying to do that
The
as
court's
well.
not allowing me to finish my statement. What I'm indicating to the court is maybe we used the wrong word, or when an argument was made, the wrong word was used in terms of jurisdiction. But the premise of the argument remained that it was not appropriate to be held in this courtroom.
Okay. I'll see your
Once
memo
we
on this
received-
tomorrow. I'll see your memo
If I
on this
can
tomorrow.
finish and make a record.
No, there's going to be a memo on this tomorrow.
So the court is denying us access to the record on this matter.
No, you've had plenty of access to the
Not-
record. I'm going to order you to
With all
prepare
due
your memo
respect,
Judge,
tomorrow.
may I-
cut us
may I-
off continuously and not allowed me to finish
Go
the
ahead and
argument.
prepare your legal
And
memo.
based
I will
on
see
the
it
new
tomorrow.
administrative order, we have come in
Thank you.
and
I'll see
made
your
that
memo
argument.
tomorrow.
Judge, may I
In
say one
addition,
more
the court
thing?
indicated that the court would no longer hear this matter, and we are making the arguments based on the new administrative order.
May I make
With the memo.
a memo for what?
Whatever you'd like to order, your memorandum of law.
I'll make the memo that this court, what has to do with the Constitution says. I cannot address.
See you tomorrow.
All right, tomorrow, Judge.
Thank you. All right.